Hello friends, today I'll tell you about cross-examination, which is very important part of any type of criminal or civil trial. Okay, if a case is listed in the lower courts or trial courts or session courts, if it's a matter of a criminal offense or particularly if it's criminal offense, or else like if it's a civil dispute, like a civil case going on in the trial courts, then or district courts, then there will be a stage of these trials where the witnesses will be examined, okay, based on the entire the evidence, Indian Evidence Act, or which is now replaced as Bharatiya Saksha Adhiniyam, okay, so BSA, which is now called. So let us assume that's Evidence Act. So based on the evidence, the courts will decide. This is part of merits, okay. The courts normally look into the evidence. Without evidence, no case can stand. So everything burns down to the evidence. Allegations anybody can make against anybody, but end of the day, everything burns down to the evidence. So what you need to understand is how important is this cross-examination. So cross-examination, before the cross-examination, there is something called chief examination. What happens in chief examination? Normally there will be a complainant as well as some list of witnesses to support his complaint. If it's a police case, normally they depose between the investigating officer and later on before the magistrate. That is called chief examination. What will be deposed before the magistrate. Alright, mostly it is called 164 statements. 161 is what you depose between the police officer. Whatever somebody says in the original complaint, later on the same will be reduced into writing into the first information report, important parts of the complaint. Then they will prepare a remand report. Thereafter comes a charge sheet. So after that, whatever the complainant has said, he will depose before the magistrate's court, and also in support, all the list of witnesses will depose before the magistrate court. So whatever they have deposed in the original complaint, along with the 161 statements and 164 statements, everything has to be very consistent. Alright, so there should not be any discrepancies. If there are any discrepancies, they are in suit. And the next thing, most important, is cross-examination. There is an art of cross-examination. Most probably I have seen in many courts, most of the advocates, 99% of them, they fail to cross-examine properly. So it will damage the complete case and of the client, and later on it will go for appeal. Once it goes for appeal in the higher courts or the Supreme Court, the entire foundation is on very loose pillars, so everything will collapse. There is nothing that even if you have the best of the best advocates in the country, they won't be able to do justice to you, because all your case has been shattered at the lower level itself. The foundation and pillars have been completely destroyed. So what you need to understand, my dear friends, is the most important thing is the cross-examination. Everything depends on cross-examination. There are only two parts in cross-examination. Normally, if an advocate advances a question, whatever, if let us assume like there is a person called X who has seen a person called Y committing a murder, or else he has gone inside a house and he allegedly have committed a murder and came back. So before going and after coming, this person called X has seen Y to commit a crime. Now what happens, the kind of question what the counsels or the advocates ask is whether Mr. X, have you seen Y going inside the house at let us say 9 p.m? He will say yes. He will say you have not seen. Then he will say no, it is not true to suggest. True to suggest or not true to suggest are the only things before the court what an advocate asks, and that will be reduced into writing. If you say true to suggest, then I will tell you, like if you ask a question like Mr. X, have you seen Y going into the room? He will say yes sir, I have seen him. Then if you ask him saying that Mr. X, you are lying that you have seen Mr. Y going inside and coming out, allegedly committing a murder, you were not there, then he will say this is not true to suggest. That means your question has completely collapsed. You have failed completely, because here you have given him a lead that he is saying it's not true to suggest that Mr. Y has not gone inside the crime scene and come back and haven't seen it and I was not present in it. So it's not true to suggest. So he's saying in indirect words it's false. So what is the point in asking such kind of question? So never ask such kind of question. You have to frame in question in such a way that you should say yes, it's true to suggest whatever he's saying, it should be in your favor. Alright. So if you say it's not true to suggest, if he says something that you are trying to annoy him by saying you were in somewhere else at the time of crime happening in this place, then he will say it's not true to suggest. Then what is again the purpose? So the whole purpose is to extract some kind of questions which are in your favor. That is by asking and extracting something which will say true to suggest. Okay, it's very difficult if you ask questions that he will say true to suggest questions, 10 questions, and which are totally against you, your case is gone. Your client will be convicted, or you will lose the case. If it's a civil case, you will lose the property or you will lose the case. If at all it is let us assume that true to suggest things are more than not true to suggest, then you will win the case. This is the secret. Okay, that is where the complete art of cross-examination and the caliber of your counsel or your advocate comes in. So lots of people I have seen in courts, even the judges ask, what kind of weird question is this? Why are you asking? What way it is connected to the whole matter? But still the counsel say, no, it's okay, I just want to ask them. So never give your your hair to someone else to catch it. Okay, by asking such kind of stupid and weird questions, you always try to extract something which is in your favor. Doesn't matter, even if you ask one or two questions which are totally in your favor, and if you don't ask unnecessary questions, you don't need to cross-examine for days and hours together and kill the court's time. I've heard that there is one of the leading murder case counsel who cross-examines for hours, minimum 2 to 3 hours, and continuously for 1 week or 10 days per witness. So what is the use? I don't think so that is correct way of cross-examination. The correct way of cross-examination is extracting only the kind of answers what you require, okay, which will create a doubt in the judge's mind whether you were really you are aware of this crime, you were there or not, or it's a kind of you have really seen it or not, or you are just trying to tell some lies. And one more thing, if you bluntly ask your witness that whatever police is saying you are deposing and you got trained and all, these are all good for nothing questions, he will anyhow say no, it is not true to suggest, it is wrong. So what is the use of such kind of useless questions when you can ask something with good preparation and kind of if you work on the complete case with a lot of skill and talent, then you can definitely make out some good questions which you can confront. The more you read the file, the more the questions you can come out with, the more lacunas you will find in the cases, because after all the criminal cases are fought on the loopholes and the lacunas that the prosecution does. And the prosecution, trust me friends, always does thousands and hundreds of blunders. Police is meant to make blunders. They are blunder kings because they are very weak in the law. They are very hardly trained. They are not advocates. They have very minimal knowledge about the law. Alright, law is so complicated that even the advocates and even the judges, to that matter of fact, cannot have the complete command on all the sections and all the acts and statutes. It's not possible for any human being. But at least they are professionals. An advocate hardly does 10, 20 or 30 cases per day. Beyond that, I don't think so any even senior counsel can appear. They hardly do 4 or 5 cases per day if they want good quality. And in the same way, the judge handles at least 100 to 300 cases. At least he hears 10 to 20 good amount of hearings per day. So he has got more knowledge than advocates. Alright, trust me, I used to think in my early days of my profession that advocates know more than judges, but I was thoroughly wrong. Judges know hundreds and thousand times more than advocates, and that's a fact. Rarely you can find advocates who knows more than judges. That's a fact, like somebody like Ram Jetmalani, or some people are there but they deserve a lot. That's why they deserve a lot of respect. But coming back to the point of cross-examination, so all that I am suggesting you is about cross-examination, where the other person, your subject is going to spill the beans is only by confronting him with questions that will embarrass him, okay, that will extract what you want. Truth or false is secondary. Whatever you are trying to extract should favor your case, then certainly it will help you. So that's all, my dear friends. So catch you later.